this today on directors and trustees. What do you need to know? So Darren Hooker from the Stone King solicitors has kindly offered to run the webinar for us. We here at Unlimited, we regularly get requests, also questions from social entrepreneurs wanting to know, them being just at that stage of thinking about setting up either a board of trustees or a board of directors, and thinking about the responsibilities, liabilities, processes, etc. So we felt the topic was really relevant, and hopefully you'll find this really useful. I'll let Darren to introduce himself properly, but just a few sort of practicalities about how the webinar runs. So we have until 1 o'clock. So the webinar itself will probably last about 45 minutes. And then at the end, we have time for questions. So have a think throughout if you have any specific questions you'd like to ask. And the way to ask them is on your control panel, which hopefully you can all see. There's an option for chat. There's a chat function at the bottom. So any questions, just put them through there, and then we will pick those up at the end, and hopefully Darren will be able to answer. So that's the main thing, 45 minutes of webinar or content, and then questions at the end. I think Darren's got a couple of questions to you as well throughout, and we'll run those via a sort of a poll system, but we'll explain that as we come to it. So big thank you for all of you. Apologies we're a little bit late, but hopefully you will enjoy the webinar, and I will hand over to Darren now.
Thank you very much, Marika. Thank you for that. And again, apologies to everyone for the slight delay starting here. That was my fault. A few technical glitches at my end. But let's cut straight to the chase. So hopefully you're all joining today because you're interested in knowing what responsibilities and duties you have as directors and trustees. Just to give you a very quick background on myself and the firm Stone King. We're a national firm with offices in Bath, London and Cambridge, been in existence for over 225 years now, and we specialise in advising charities and social enterprises. About 70% of the work that we do is with charities and social enterprises. Personally, I've been with the firm for 5 years, having trained here, and I qualified into the charity and social enterprise team because it was an area of particular interest to me. And I've just included a photo of me there, so you've got a vague idea who's speaking. So this is just an outline of what we're going to cover today, and then moving on to regulators and stakeholders. So what I've included on this diagram is a visualization of all of the people who should matter to you as a director of a company or as a trustee of a charity. Now, some of these will be quite obvious to you. You have your regulators, such as Companies House and Charity Commission, and HMRC. And some of them might not be so obvious to you, so let's just speak about a few of these. So HMRC, the tax man, clearly a very important regulator for you, particularly if you are a charity, because you'll be receiving tax exemptions such as from corporation tax or income tax, and making gift aid declarations. May also be important to you as a social enterprise such as a community interest company, particularly next year when the social investment tax relief comes into play. Whether or not you do claim tax exemptions, you will have to report to HMRC and ensure that you pay the correct tax in any year, so a very important regulator for you. Underneath HMRC we then have funders and partners. Clearly those people who are putting money into your social enterprise are going to have an interest in how it's run, and broadly the more money they put in, the more of an interest they're going to have, and the more control that they will want to have over how that money is spent. So you might have contractual obligations to ensure that money is used for a particular purpose, or they may go further and require that they have an element of control, perhaps a requirement to appoint directors to your board or to hold a certain percentage of the shareholding. So you need to be aware of who your funders are and ensure you keep them on side. Your beneficiaries, the people that you are set up to help, clearly they have an interest in how your organisation operates, so you'll want to do all that you can to ensure that they continue to support you. Your members, and what we mean here is people who have an element of control, a degree of ownership in your business, typically shareholders in your commercial companies, but it may also be employees if you opt for a cooperative structure. Again, those individuals are going to have a vested interest in how your business performs. Your competitors clearly also have an interest in how you perform, but perhaps they're interested in you performing not to your full potential, but you need to be aware of what your competitors think of you and what messages they might put out there to the public about you. The ICO is the Information Commissioner's Office, and this is the regulator which is responsible for data protection issues. So if you're handling personal data, particularly sensitive personal data about individuals, about your members, about your beneficiaries, then you're going to have requirements under the law to process that data, to handle that data in a particular way, and the Information Commissioner's Office is going to oversee that. They're also responsible for looking at Freedom of Information Act requests and how they're complied with, which will be relevant if you're a publicly funded organisation. Moving up then, we have the media and public, and arguably this is the most important stakeholder to you, and I'm going to keep coming back to them throughout this talk. We're going to have a look at a few case studies where charities have perhaps and social enterprises have perhaps underestimated the importance of media and public. And then the final two bubbles there are Companies House and Charity Commission, and we'll have a look now at what that might mean for you. So this slide here, what you can see is a screen grab of Charity Commission register. What I'd like to do now is just run a couple of quick polls, Marika, if I may. Firstly, how many people watching this webinar are themselves registered charities or are considering becoming one?
Okay, thank you, Darren. Now let's just actually looking at because I can see the attendee list. Looking at the attendee list, we have a few people who I know are not set up as anything, but let's just run. So, are you a registered charity or considering becoming one? And that should show on people's screen. So if everybody who's participating, if you can give us your answers, and I will close. Thank you very much. We have, so the answers that come through, Darren, on the first one are 50% no and 50% not sure yet. Because I gave people option yes, no, or not sure yet. Because I know that often people we work with, they are sort of just at that stage of trying to decide. So no one is a registered charity. 50% say no, 50% say not sure. If that's okay. Do you want to do the second one as well, just the company?
Yes,
I see.
Please. Yeah. So exactly the same question. How many of you are companies or are considering becoming one? And that includes community interest companies, KICs.
Great. So we will launch that. And the same thing again, just click your answers, just put them through. Oh, that's interesting. So 100% of answers, let me just wait if anyone else wants to add in, is yes. So I will close that poll. Brilliant. So everyone who responded to that said yes to a company. So it looks like we haven't got charities, but we have companies.
Okay, perfect. Well, thank you very much for that. I'll just touch a bit then on charities. Sorry, Marek, I think I'm getting some feedback from you, your mic. Okay, it's gone now. I'll touch a bit on charities just because a few of you there are potentially interested in them. but I'll focus very much on companies then. So, I mean, broadly, the big benefit of being a charity is the tax reliefs. You get, as I mentioned earlier, exemption from corporation tax, exemption from income tax, and you can claim gift aid on donations that you receive. The quid pro quo for that is that you'll have a very stringent regime of regulation governing you and very public reporting requirements. So what we're looking at here is the home screen for the Charity Commission's website, the Charity Commission's entry, which is available on its website for this particular charity. And you can go to the Charity Commission's website and search for free for any registered charity. And you'll see here there's some reasonably detailed information on the finances of the charity. If you delve into the website, Charity Commission's website, you will find much more detailed information about charities. Why I wanted to highlight this particular entry was because you'll see at the top here it's been bordered red, and it then says documents overdue, and then further down the page we have accounts not received in the last financial year and just coming up to 2 months overdue. So this is all to do with your regulators' reporting requirements. As I say, the quid pro quo for the beneficial tax reliefs that you receive as a charity is that you have ongoing filing requirements, reporting requirements with the Charity Commission. And it's very important to ensure that you comply with those. As I say, this information is publicly available. This is the very first screen that someone will see when they're doing some due diligence on you, which is inevitably something that your funders will do, that your stakeholders, your members will do when they're thinking about interacting with you. So just consider how this page here might look to your supporters, to your stakeholders, and whether you think it might affect their trust and confidence in you. Moving then on to Companies House, very similar format here, albeit without colours, but you'll see that again this is publicly available information. On the right hand side of the page there you can order more detailed information on the company. So you can order company accounts, their governing document, appointment forms and so on. And at the bottom of the page there again you have the accounting details. So this company has not yet filed accounts, but that is because it's quite new. You'll see it was set up in October 2013. So again, very important for companies, as with charities, to ensure that you are up to date with your filing requirements. The website might not go red in the same way it does for the Charity Commission, but what Companies House does do, which the Charity Commission doesn't, is issue penalties for late filing. So we have a table there. The column marked private company is the one going to be relevant to you. And you'll see that if you are late in filing your accounts to Companies House, you can be issued with a fine of between £150 and £1,500. That penalty does double if you are late 2 years running. So if in your second year you are more than 6 months late with your filing, that fine will go up to £3,000. And it's also worth noting that failure to file accounts is a criminal offence. So the directors of a company could also be taken to court and fined personally for, I think it's up to £5,000. So very important to ensure that your accounts are filed on time. I've just included on this slide some facts and figures about late filing penalties in the last financial year. So this is from April 2013 to April 2014. 157,000 penalties imposed, 30,000 appeals received, but only 0.6% of appeals were successfully upheld. We often get clients coming to us saying, oh, we've been issued with this penalty, can we appeal it, is there anything we can say? And the simple answer is no. There's really not anything you can do to appeal a late filing penalty from Companies House. Even if your accountants mess up, if you lose the forms, you're just not going to successfully appeal that. So prevention is much better than cure in this case. And the last bullet point there, I found this frankly staggering, that the total value of penalties issued in the last financial year just in England and Wales, £77.5 million. It's an absolute waste of money. I'm sure you could think of much better things that you'd like to spend your money on. Think of all of the good things that your business could do with that money. And these penalties are totally avoidable. You have 9 months after your financial year ends to get your accounts to Companies House. So there really is no excuse for being issued with these penalties. So don't become part of those stats. On the diagram we opened with, I mentioned the media and the public as being your key stakeholder. Now, arguably the most important asset of a business, and particularly a social business, is the one that's most difficult to quantify. It's brand. Whilst you may be issued with penalties by Companies House or other regulators, and there's a very clear detriment to you there, if your brand is damaged, it's very difficult to recover from that. And often we get clients coming to us, they've got perhaps an idea of something they might do that might be a bit risque, and they say, can we legally do this? And the answer may well be yes, but the response we give them is not so much a legal response. We're not saying, let's apply this case law. The test we apply is the Daily Mail test. What would happen if the Daily Mail or any other newspaper gets hold of this story about you? How would it look plastered across the front page? And more often than not, the answer is very badly. So please don't underestimate the value of your brand as a company, as a social enterprise, as a charity. It really is the most important asset you have, so treat it accordingly. And then what I've included on this slide is just some further headlines from the past 18 months from The Guardian, many social enterprises critically ill, Daily Mail, Save the Children boss getting £160,000 of bonuses, and the last one probably something you've all heard about, Amazon, Google, Starbucks being attacked over tax avoidance. Now for those businesses there's a clear detriment to them. You may have seen boycotts, people trying to implement boycotts of these businesses, and so they've got a thought process to go through there. Is the amount of money we're saving in tax worth the potential damage to our business, both in terms of lost customers and just general branding issues? So again, I'd like to run another poll here without getting into the details of exactly what the likes of Amazon, Google, Starbucks did. If you were in their position, if you were CEO of one of those businesses, would you be willing to take what I think people would describe as an aggressive tax policy to save yourself some money at the risk of damaging your brand? So Marika, would you be able to run a poll on that?
Great. Thanks, Darren. So there's your question, and let's just wait for people to answer. So the poll should be showing on the screen, and just click yes or no. Would you, if you were in the same position, would you do the same as Amazon, Google, and Starbucks? Okay. Unsurprisingly, 100% have said no, although I guess one could argue that it's a difficult one to say what you would actually do if you were a CEO of a company of that size, but at least in principle everyone is saying no.
Yeah, well that's thank you for that, Marika. It's very good to hear that we've got a moral group of individuals here. You are right that I think it's a different question for the likes of Amazon, Google, Starbucks. You might expect that businesses like that are to take a more aggressive line, and I would certainly say for the likes of charities and social enterprises, you really don't want to be caught up in these kind of arguments, because it really undermines what your business is about. But that's interesting and reassuring to know. So that concludes a look at the key stakeholders and regulators in the sector. I'm now going to spend a bit of time talking about key duties. On the next couple of slides I have duties of charity trustees, but I'm not going to cover those in great detail. I'll focus on these ones as company directors, since that's where the interest is. So these bullet points on the page, these are all Companies Act duties, so these are duties set down in law that you as a director must comply with. So the first one, acting within your powers, and what this really means is only doing things that you are allowed to do, either within the law or by your governing document. And your governing document as a social enterprise might contain, for example, your mission statement. You might be an educational organisation that's set up to advance education throughout the world. If you are set up for that purpose, then you shouldn't then be straying into other areas and doing perhaps poverty relief work, however noble that may be. So what you need to do is look at your governing document and ensure that you comply with it, and also follow the decision-making process that is set out within it. The second duty there is to promote the success of the company, which seems quite straightforward, and in the case of Google, Starbucks and Apple, promoting the success clearly means making the most money for your organisation. But where you have a social business or a charity, you have to remember the reason why you are set up. It's not just to make the most money, it's to help your beneficiaries as well. So to be fulfilling this duty, you need to be having those beneficiaries in mind and promoting their well-being as well. Then we have exercising independent judgment. The important point here really is that as a director, you are personally responsible. You are the one who is responsible for these duties. It's your role. You can't hide behind other directors, so you need to take responsibility for decisions you're making. You're not there to serve anyone else's interests. Avoid conflicts of interest. Now this is such a key area that I'm going to spend a bit of time talking about this separately as an issue, but I would just say that it is a really key issue and one which people often get wrong, and later on we'll have a look at some cautionary tales where some well-known organisations do get this wrong. The duty not to accept benefits from third parties. This really undermines your duty to promote the success of the company, and also, are you really avoiding conflicts of interest if you're accepting benefits from third parties? And then the final bullet point there is to declare an interest in a proposed transactional arrangement. Again, that links back to conflicts of interest, so I will talk about that in more detail shortly. So that's just an outline of the duties on company directors. Hopefully nothing there. I'm sorry, I've just realised I missed one, which was to exercise reasonable care, skill and diligence, which hopefully doesn't seem an unreasonable duty for you. The law expects that you will be reasonable, but you don't have to be an expert in everything. You just need to know where the limits of your own capabilities are and take appropriate advice as and when you can. So as I say, hopefully nothing there that's totally shocking to you. If you're being a reasonable person, you're being prudent in your roles, then you will unwittingly be complying with all of these duties anyway. And then we have the charities duties. I'm not going to spend any time really talking about these, only to say that they very closely mirror the ones we've just been looking at. So you'll see, for example, the first bullet point here is to further the purposes and interests of the charity, and that's very similar to promoting the success of the company, ensuring the charity is and will remain solvent, again promoting success of the company. So all I want to say about these really is that if you do become a registered charity, don't get unduly worried about the fact that you then have two sets of responsibilities. They more or less overlap, so if you are being a reasonable and prudent director, then undoubtedly you'll also be being a reasonable and prudent trustee. And if you want any further information about charity duties, the Charity Commission does produce some very useful guidance, just noted at the bottom of the slide there. So conflicts of interest, as I say, this is a really key issue. The picture that we have here, this is in response to a story about the Food and Drug Administration in the United States of America. And that's an organisation which has been set up to protect the public from dangerous food and drugs. So it's a regulator that reviews particularly drugs that have been produced by pharmaceutical companies to make sure that they are safe for public consumption. But a story was leaked that actually the organisation receives a large amount of funding from the pharmaceutical companies that it is supposed to be evaluating. And so its own success, its own interests are linked to success of the companies it's evaluating. And I hope you can all see that that is a potential issue here, and it really undermines the FDA's reputation as a regulator. So on the right-hand side of the slide there, we have a definition of a conflict of interest, which is any situation in which a person's personal interests or interests they owe to someone else may, and this is the really important part, or may appear to influence or affect the decision making. Arguably, it's more important what people see and what people think than actually what has happened. In this example here, the FDA, the individuals there may very well be able to separate in their mind their separate duties and say, I'm definitely not making this for the wrong decisions because we receive funding from them. But the perception is there, and that really does matter more than actually the reality. It all comes back to the branding, the importance of your reputation as a social business. So where might conflicts of interest arise? Well, three main areas: financial conflicts of interest, professional and personal. And the examples I've given at the bottom here, the first one is the most obvious example. If you are a director of a company and you want to receive a salary from that company, then there's a clear conflict of interest there. On the one hand, you want to receive the most money you can as an individual, and on the other hand, you want to ensure that the company is as successful as possible, which may mean negotiating for a lower salary. So it's a clear conflict there. Second example is of a director's wife making a loan to the company, and there might then need to be negotiation about the terms of the repayment of that loan. Husband and wife are considered so linked that their interests are tied up with one another, so that the wife's financial interests are the husband's financial interests. So the husband in that case shouldn't be negotiating the terms of the loan. And then the final one we have, this is a bit more abstract, a company in which a director owns shares competing for a contract. And this does get quite difficult because a lot of directors may over time develop a share portfolio that may be managed by another third party that actually they don't take a very active interest in. But it will still look very bad if your company ends up awarding a contract to a business in which you have a shareholding. If we come back to the Daily Mail test, that's going to look very bad on the front page. So conflicts of interest, how do you deal with them? I think the important point to note here is that you can never avoid conflicts of interest. They are an inevitability. There will be a time when you have another interest which conflicts with your interest to do the best for your company. The important point really is how you go about managing them. And as you'll see noted on the slide here, transparency is the key. You want to be open about the way in which decisions are made so that they can be defended, so that if the Daily Mail comes to you and says, well, why has this contract been awarded to that company, you can say, here are minutes, here are notes, this is the reasons why, and then you have nothing to fear. So maintain a register of interests. Have every director or senior member of staff complete a form noting all their conflicts, potential conflicts of interest, so that they can be managed when they do arise. Have conflicts of interest as a standing agenda item at each meeting, and have each of the directors think ahead as to whether they might be conflicted on talking about a particular matter. If there is a conflict, then that person should declare it to the rest of the meeting and then withdraw from the meeting, so that they're not then able to influence discussions, and it can be said that the remaining directors took the decision impartially. Is there a quorum of non-conflicted directors? Are there enough people without an interest in the transaction for a valid decision to be made? There is scope for directors' conflicts of interest to be authorised either by a regulator such as Charity Commission, or there might be a procedure in which it can be done under the governing document. But the important point really, as I say, is to ensure your decisions are recorded accurately. If you are authorising conflicts, then have very clear reasons why you are doing that, have it noted in minutes, have it disclosed in your accounts, so that you really then have nothing to hide, because even if you don't have anything, even if it is a justifiable decision, if you are covering it up in some way, it's always going to look worse. So what are the consequences of not managing a conflict of interest? Well, it may be that your directors are acting outside the terms of the governing document. It may be the case that you are not promoting your company's best interests in allowing this conflict to continue. And in those cases, you could potentially be looking at personal liability for any loss which your company suffers as a result of it. You may also find your decisions challenged by interested parties such as your regulator, and again we come back to the Daily Mail test and the importance of your reputation. Allegations of conflicts of interest not being managed properly, allegations of impartiality in the decision-making process can really damage your brand. And if you want more detailed guidance about conflicts of interest, the Charity Commission does produce some very, very helpful guidance on it, which is relevant for companies as well as charities. Just going to touch briefly on governance and management, because I'm aware that we're shortly running out of time. When we talk about governance, we are speaking about the directors of a company or the trustees of a charity, and these are the individuals who owe the duties under law to promote the success of the company and so on. The management side then are your key employees, your CEO and your more junior level staff. And their two roles are quite distinct. The trustees, the directors, they're the ones setting mission, policy, strategy, and providing the insight, wisdom and judgment. The employees, on the other hand, they're the ones implementing the strategy, taking the day-to-day responsibilities. Inevitably there is some degree of overlap in those responsibilities, particularly if you have a good CEO who's going to be acting as a link between your directors and your employees. But do remember that they are distinct roles, and as directors, even though you have your responsibilities under company law, you have to let your staff get on and undertake the role which they've been appointed for. Don't micromanage your staff, is the message there. So what happens when things go wrong? You might have the best of intentions in setting up your company and pursuing various contracts, but success isn't always guaranteed. Unfortunately, not all businesses become as large as Google and Apple. So what happens if you do end up losing money for your company? Well, generally speaking, companies and company directors are not going to incur any kind of personal liability, and this should be the main reason that you should consider setting up as a company. If you are an unincorporated organisation such as a trust, or if you're acting personally, then you are going to be signing contracts, employing staff, entering into leases in your personal name, and by signing those you're then risking your personal assets if something goes wrong, because you could be sued on that contract. A company, on the other hand, for legal purposes is considered a person. So when you're signing your contract with Google, you're signing your contract with Google, not with the directors, or not with individual members of staff. So if something does go wrong on that contract and you need to sue them or you need to claim compensation, you will do it from Google, the company. You won't do it from the individual members of the board. And that's really, really important. If you are considering entering into contracts and so on, then you really should be considering setting up a company. There are only very, very limited circumstances in which you might be personally liable as a company director, but you'll see at the bottom of the slide there, if you act prudently, lawfully, in accordance with your governing document, and if you fulfill the duties we looked at a few slides prior, then you have no reason to fear personal liability. There's only a few instances where personal liability might arise. So if you're acting ultra vires, which basically means beyond your powers, you're breaching your duties, then you may find there that you are liable to be personally responsible for the deaths of your company. If you're undertaking fraudulent activity, then again you might find that you are personally liable. Or if you're undertaking wrongful trading, and what that means is if you know that your company is insolvent, but you go on incurring costs anyway, so you know your company's insolvent, but you decide to buy a fleet of cars with it just before bankruptcy proceedings are started, then it would be incredibly unfair on that car provider to not be able to claim. So in that case, you would likely find yourself personally liable. And as we mentioned earlier, there are some personal fines for late filing of accounts with the Companies House. But as I say, I don't want to scare you with these potential instances of personal liability. In 99.9% of cases, they won't arise. And as long as you comply with your duties, as long as you act reasonably, you will have nothing to fear. Just to flag on this slide that this is your decision. You are the director. As I mentioned earlier, you shouldn't be hiding behind a decision-making process. You shouldn't be being very passive with your fellow board members. You are collectively responsible for your decisions. And what that means is that you are together responsible. So if collectively as a board you make a bad decision, then you are all individually responsible for it. It's not enough to say, well, actually it was that guy who drove the decision. You need to take responsibility for your decisions. It's you're the one with the duties under company law. So these are just some questions here that you might consider asking yourself whenever you're taking decisions as directors, just to make sure that your decisions are justifiable. We're now just going to have a look at a few high-profile cases of where organisations have got some of these rules wrong. So the Andrew Lloyd Webber Foundation, this is an organisation established to advance the arts, culture and heritage. And the way in which it does this is by displaying works of art that it owns at various museums for public enjoyment. Andrew Lloyd Webber, who you may know as the writer of Phantom of the Opera and Cats and so on, he donated various pieces of art to this charity when establishing it. When the pieces of art are not being publicly displayed by the charity, he then licenses them back and he pays a fee for doing that. So you might consider, what is the issue here? It seems like a relatively above board operation. And actually the charity's governing document, its trustee, allowed the transactions to occur, provided that at least one trustee had no interest and there was an independent valuation. But what I've listed on the slide here is the three trustees of the organisation: Mr. Lloyd Webber himself, his wife, Lady Lloyd Webber, and his solicitor. So I hope you can see here that all three of these individuals clearly have an interest in the transaction. They're all linked in some way to Andrew Lloyd Webber, and may not be able to take impartial decisions as to whether the organisation should contract with Mr. Lloyd Webber. There's a further conflict here in that Mr. Lloyd Webber's solicitor provided legal advice to the charity and was paid for doing so, which again, clear conflict of interest there between him wanting to obtain best value for his services and the charity wanting to obtain best value for itself. It's possible, I think, here to actually have some sympathy with Andrew Lloyd Webber. There was no suggestion that he'd actually done anything untoward. He donated very valuable pieces of art to this organisation. He then, whenever he wanted to use one of them personally, he would get an independent valuation and often paid above the market value to do that. But the lesson here really is that the perception was that there was a conflict because of the link between the three trustees and the transactions taking place. The perception was very much that something improper was occurring here. And as you'll see at the bottom of the slide, the Charity Commission said that the decisions were vulnerable to challenge. It just wasn't clear in whose interests the decisions were being taken. So a lesson there about the perception of conflicts of interest. Second case we have here concerns Plymouth Argyle Football Club, which some of you may know is a football club that went into administration some time ago. and its links with a supporters club, Plymouth Argyle Supporters Trust. Now that again was a charity established for leisure and recreation purposes, providing facilities for young people. Its board was drawn from various supporter clubs of the football club, and there were also two people on its board who were also directors of the football club. Now, as the finances of the football club were beginning to go a bit sour, the organisation decided to make a loan of £330,000 to the football club, but without adequate security. Now what happened was, in spite of receiving the loan, the club went into administration, and then it wasn't possible for the supporters trust to get its money back. They hadn't taken adequate security on the loan, and there were outstanding creditors in any event. So in short, they ended up losing the money. And you'll see some fairly scathing criticism here of the trustees. They all had interest in Plymouth Argyle Football Club, and they've not managed their conflicts of interest. No adequate security was taken to safeguard the money, no professional financial investment advice sought, and they didn't follow the governing document by managing their conflicts correctly. And the simple question here, was the decision made in the best interests of the trust, which they were directors of, or of the football club, which they all had links to? And in short, this decision was just indefensible. It was clearly in the interest of the football club. So a very clear failure of duties there. On this slide we have the National Bullying Helpline, which is a organisation set up to protect people who suffer from bullying, and particularly they do that by operating a confidential helpline. And what happened here was that the CEO of the organisation made various public statements about, well, in response to allegations of bullying occurring at 10 Downing Street, and effectively they alluded to the existence of calls coming from the Deputy Prime Minister's office. So why was this an issue? Well, it undermined the reason why the organisation was set up. If we go back to our very first slide and we think about the stakeholders in an organisation, one of the key ones is the beneficiaries, and the action that the CEO took here potentially identified the individuals who were supposed to be receiving confidential advice and help, potentially identified them and undermined the purpose for which it existed. So there's a negative impact on the trust and confidence in this organisation. As an aside, there was also another conflict issue, just to really highlight that this is a recurrent issue that lots of organisations seem to get wrong. But the Charity Commission, all in, was very scathing. As I say, said that the CEO's actions undermine the trust and confidence in the organisation and the organisation's reputation. So again, another lesson to be learned there. The last case we're going to look at here is Comic Relief, and what I've put on this slide here is Comic Relief's own mission statement, which is taken from its website, which is to drive positive change through the power of entertainment. And you'll see some criticism here from an investment manager who says that Comic Relief is risking its reputation, and its reputation is very precious. So what is it Comic Relief did? Well, between 2007 and 2009 it operated an investment policy which led to it investing £3 million in tobacco companies, £600,000 in weapons firm BAE, and £300,000 in shares in alcohol industry, including Diageo, which is responsible for managing brands Guinness, Bailey's, Red Stripe, Captain Morgan. And the picture you see there is from a Captain Morgan advert. Diageo itself has actually got a slightly damaged reputation in that it has run into some trouble with advertising standards in the past, and that picture you're looking at there of Captain Morgan you might have seen recently, but you won't see again because it's had to be withdrawn for the image it portrays. So why did Comic Relief choose to invest in these particular industries? Well, it felt that the financial return was the most important factor here. Why didn't they invest in ethical funds? They believed that it produced too low a return on their investment, and on balance, they believed that the approach of investing in any organisation for the greatest financial return provided the most benefits to the most vulnerable people. So again, I'd just like to run a quick poll here as to whether you feel you would continue to donate to Comic Relief, having found out that they don't operate a totally ethical investment policy. I should just stress that this was only between 2007 and 2009. As a result of the criticism they got, they did change their investment policy, so they're not still doing this. But it would just be interesting to know whether, if something like this occurred again, whether you would still consider donating to that organisation. Marika, would you be able to run a poll here?
Okay, thanks, Darren. Okay. And we've got two-thirds, 67% say yes, I still would donate, and one-third, 33% say no.
Okay, thanks for that. That's interesting. It's probably a bit more generous than I was expecting, actually. But again, it highlights that there's likely to be a significant reduction in your ability to attract donations should you operate a policy like this. And there's no suggestion that Comic Relief in this case have actually done anything illegal, but it does go rather against the purpose for which they're set up. So I'm just going to conclude, because we've only got a few minutes left now, just with our top 10 do's and don'ts to hopefully just bring this all together. So don't just know your governing document, follow it, and particularly look at your objects. Make sure that what you're doing is pursuing your objects and follow the decision-making process, including conflicts of interest, set out within. Don't rely on anyone else. Read the papers, be heard, be involved, and be a critical friend. So again, this is about ensuring that you personally comply with your duties. Make sure your decision-making process is robust. A bit of debate at directors' meetings is healthy. They shouldn't be looked on as a bad thing. Avoid unnecessary risk and take proper advice. Again, that goes back to being a reasonable director, knowing the limits of your own capabilities, taking advice where necessary. Manage your conflicts of interest. Hopefully you can see from some of these tales that I've just been speaking through that conflicts of interest is a very important issue, and it has the potential to really damage the brand of your organisation. Don't micromanage, delegate, don't abdicate. You have to let staff get on with their roles, but ensure that there is a process there for monitoring how they're performing. Keep a 360-degree legal eye. Keep an eye out what's developing in the industry. What are the legal changes occurring? What else is going on in your industry? And finally, know when to stop and retire. You obviously all have very good ideas, and you need someone like yourselves with the impetus and the drive to really get these businesses off the ground. But don't be scared of change in the future. Often you need to pass the baton on to someone else to help move the organisation forward. So do know when to step down and embrace change, because it can be a good thing. And that concludes the talk. With just a couple of minutes to spare, I'm happy to take some questions if we've got time. Otherwise, I don't know if there's another means I can take questions, Marika, perhaps by email or.
Yes, thank you so much, Darren. If you're happy to, then yes, we have often offered an opportunity. So if anyone's got questions that come to your mind after the webinar and you'd like to get some clarification on, then Darren, if you are happy for people to contact you, then I can connect. I can connect people up. Normally what I do afterwards anyways, I send people the recording and also links to our previous webinars. So on that I might just CC you in, Darren, and then that way people have your email address should they have questions. So right now, yeah, we are really coming to the end of this now. I had a couple of questions that I thought of. So perhaps if people want to have a think, and if there's anything that comes to mind, please type your question in the chat function, chat box at the end. But something I wanted to ask you, Darren, is there, let's say I'm the founder of a social enterprise, for example, and I'm looking at setting up my board of directors for the first time. Is there a minimum number of directors I should have? Is there like a best practice, some sort of guidance on?
Yes. I mean, legally, you only need to have one.
Okay.
That's what company law says.
Yeah.
Charity law is slightly different in that the Charity Commission would always expect you to have at least 3. Okay. And that is what we would recommend for companies as well, because it comes back to the conflicts of interest point. If you are just one person on the board of directors, what are you then going to do if you suffer a conflict of interest? You need to have at least another person there independent of that, so they can make the decision without you being present. And we always recommend an odd number just because it then avoids stalemates.
Yeah, 50-50. And is there anything then, say you find 3 directors who I assume tend to be, it's a voluntary position, they offer their time for free. Is there any kind of contract or even some kind of a agreement in principle that would be a good idea to set out expectations, roles, responsibilities? Do companies do that with their volunteer directors?
Yes, they do. I mean, you have to be careful about how you phrase it because, as you say, these people are volunteers. They're giving up their free time. So if you serve them with a 40-page employment contract, you're going to scare them off. But it would certainly be a good idea to have a short document just setting out the key responsibilities and expectations, but framing it in a positive way as well. So offering it as an opportunity for them to really drive the organisation.
Yeah. Okay. So something maybe drafted together, sort of just covering some bullet points on
yes,
what's
exactly.
expected and how things work. Brilliant.
Yeah.
Okay. Well, listen, I think we're going to draw this to a close now, which is a couple of minutes past 1 o'clock. So thank you so much for your time. Really appreciate you hosting this webinar and all the other support you provide, Unlimited, and our social entrepreneurs. So thank you for this, and for everyone else, all the listeners, thank you for tuning in, for dialing in. I'll follow up with a quick email later today or tomorrow with dates for future webinars as well. So if there are any that are of interest, then do join us again. But for now, just everyone have a really, really great afternoon.
Great. Thank you, Marika. Thank you, everyone.